She clearly, if I were to believe the letters were written by Lynn, she wanted to meet him, but yet she never did. I don't think you wanted there to be any possibility of questions. And that's why I think, however you did it, you were able to keep Lynn isolated so that other people wouldn't question and perhaps uncover what was happening with the thefts. I know that you still have the strong support of your mother. I question at times whether that's healthy or not. If she's seeing things clearly, I think she's, one of the few individuals who has, really bought the story, lock, stock, and barrel, that you have spun. I think as a mom, we want to always see the good in our children and don't want to believe the worst, and it's really challenging and difficult to believe that your own child is capable of a homicide. It's either that or she's complicit, and she knew, and she was involved. I don't know. The seriousness of these offenses are significant. As a homicide, there's a loss of life. It is intentional. You are convicted of intentional homicide, not, for example, what some people might call manslaughter or even assisted suicide. And I know you probably don't agree with the decision that I made on that either, and that's okay. The law just did not support it. But here there was an intentional poisoning with a very specific intent for it to go undetected over time to cover up your thefts. It's aggravated in the sense this was a planned series of events. This was not, a crime of passion, for example. You have a relatively minor record, even though there's 4 felonies. You don't have anything other than that. You didn't have issues as a juvenile. But there were thousands and thousands of dollars that were stolen by you before Lynn Hernan was killed and after. And it's all really related in terms of the seriousness, because you really don't have one without the other, because I do think the homicide was related and the motive was to cover things up. It was to not get caught and to do it in a way that you thought you could do to get away with it. I talked about the scene a little bit, and I think there's some aggravated factors about that. The way that scene looked, Dr. B talked about her opinion. She testified that she thought it was staged, that she was concerned about it. It was not something she had seen. And, whether the body was moved or the tray was on her chest before or after, there were pieces that appeared to be pieces of pills strategically placed in the corners of Lynn Hernan's mouth. I think it's inescapable that they were placed there. None found in her mouth, but only in the corners. I somewhat agree with you that through the transport, through the EMS people being there, some of those things would have fallen on the floor, would have been scattered in other ways, and that's very possible. I just don't think that would be responsible for those pieces in the corners of her mouth. These were crimes over a significant period of time. These were crimes that required planning, preparation. Once Lynn Hernon was killed, the amount of deceit and deception really accelerated. We have these letters. Even if I take those off the table for a minute, we have everything that was done in that probate case. The false invoices, the loan against the inheritance, and then using the estate funds to pay back. I mean, those were things that, from my perspective, were pretty easily proven. That paper trail, that was dismantled pretty quickly. And then we get to the point in time where police now, law enforcement are now zeroing in on you. We know in about March, when you met with Detective Cole and Detective Hoppy, that, and that really only happens after you make some phone calls and you're told the ME's office, they're not going to talk to you anymore, however that kind of worked itself out. But we know they reached out to you because you called. There's a recording of your call seeking information from them. And that's kind of I think, a pivotal point, because I think for you, you knew something was going on. They didn't tell you at that point. They don't tell you until July about the THZ. But that would have been a really good time if you had evidence that Lynn Hernon committed suicide, that you raise it, that you bring it forward. Or that if it did exist, you get it out of Whitnall Park, you put it in a safe deposit box, you put it in a storage, you put it someplace other than a park, if it truly existed. There were so many opportunities for that to be brought to police. And yet, and this is where your character comes into play, you want to turn the tables on law enforcement and say, you didn't do enough. You should have taken me out of custody. I should have had those 2 weeks to go search to find it myself. You didn't even have as much of a photograph on your cell phone to say, here's where it is. I kept a document, I kept a record of it just in case. Nothing. See, all things that I think, if this were legitimate, someone would have done or had. So fast forward to July of 2019. 6 different interviews, 6 different versions of events, and not one really making a whole lot of sense. You yourself admit, I lied. You should not be shocked, Ms. Kurczewski, that people don't believe the stories that you tell. They don't add up. They don't make sense. They fly in the face of logic. They are far too convenient, and most often have extra detail added after you're given information from law enforcement. As if you went back to your cell, how can I explain this away? And I think you rely far too much on your intelligence and your ability to think on your feet, thinking you can outsmart law enforcement. And the thing is, they're going to look at everything. They're going to uncover everything that they can. You want everyone in this courtroom to believe you should not have been convicted because law enforcement didn't look into the death of Lynn's mom. They didn't need to. They had enough evidence. The evidence was clear. It pointed directly to you. But you had an opportunity, I think many times, to accept responsibility, to just admit. And I don't think you're able to do that. You're going to stand firm on this was a suicide, and no one will convince you otherwise. But you know what you did. You know you're the one that took Lynn Hernan from this earth. You know you're responsible because your own words say that to me. I knew she was drinking Visine. I helped her. I was filling up the bottles. I'm paraphrasing. I'm not going to get it exactly right. But your story morphed to the point you admitted you knew Lynn Hernan was suicidal, that at one point she put a gun to her head, and that she had been drinking Visine for months. If that were true, and you loved this woman with your heart and soul and cared about her well-being, I believe Lynn Hernan would still be here because you would have gotten her help. You would have told her other friends and family that you may not have had a lot of contact with since you got out of prison or even ever, but you certainly knew about them. You had access to Lynn's phone. You would have reached out to everyone and anyone and said, this woman needs help. She's suicidal. But that's not what you did at all. I know you think that I came into this courtroom today having made up my mind on what to do in your case. I'm going to tell you I didn't. I would go back and forth. Should I give her life without the possibility of extended supervision? Should I give her this eligibility at some point in time? I made myself a sheet, and I had blanks for those things. Now, I knew what I wanted to do on the theft charges. I'll give you that, because those are pretty simple. They're 10-year felonies. The max is 5 years each, 5 initial confinement, 5 ES. And really the issue was, should they be consecutive or concurrent? And I'd go back and forth. I'd talk to my clerk. I'd say, I'm kind of struggling here. I want to find a reason. I listened to the state here today. They're pretty darn compelling as to why there's no redeeming qualities. And Attorney Jones said something really interesting during his sentencing remarks. You know, for everyone in this courtroom, the defendant, the defendant's family, to Mr. Poza, to his family, to all of Lynn's friends, even the detectives maybe, but probably less for them. This is the most important case. That's why you get people like Jim Kelleher saying, I want life without the possibility of parole, and you get a request for leniency from those on your side. That's very typical. But what he said, what Attorney Jones said, and what he talked about is, we look at the system of justice. We have to look at the degrees of homicides. To look at the cases really based on my experience, right, in other homicide cases, what's come through this county, and just generally kind of what we know in the justice system. And that really kind of stuck with me. And he said to strip the defendant of any eligibility would be too harsh in this case. I'm paraphrasing. And that we should trust the system because it's not an automatic. All it is an eligibility. That made me think. I know you're roughly 40 years of age. I thought about making you eligible at 62 years, meaning 62 years of initial confinement. I thought, well, at 40, I don't know that, I would put her into triple digits. And I thought about what others have said in terms of, you're less of a risk when you get older, especially if you're in your 70s, 80s, whatever. And I don't want to, unduly depreciate the seriousness of you taking the life of another person. And even though I think you're completely diabolical, and I think this was planned, and I think you have evil in your heart, when I look at what else I've seen through my tenure, when I think of the system as a whole, I think this is one of those cases that it would not unduly depreciate the seriousness of the offense to make you eligible for extended supervision at some point. So then the question becomes, at what point? I think for me, it's important to think about how old Lynn was when her life was cut short, and she was 62. Under the statute, the earliest I could consider eligibility is 20 years. Now, this is not what I would call minimums eligibility case. You have a prior record for 4 felonies. You've been to prison previously. You've been revoked twice while on extended supervision. You have issues with conforming your conduct to the rules and expectations that are placed upon you by the justice system. However, it's your first violent offense. You don't have a history of harming people, physically, assault behavior, certainly not a prior homicide, not even like an OWI homicide or anything. You just have that prior OWI first. Knowing that I believe consecutive sentences for those thefts are important, and I'll get to the reasoning why. On the first-degree intentional homicide charge, count 1, I'm going to impose a life sentence with the possibility of extended supervision after 30 years. That would make you, without the theft charges, close to 70 years of age, older than what Lynn would be today. Physically older, I think 30 years is a pretty significant amount of time. But my target is really 80 for you. That is why on counts 2 and 3, you're going to serve maximum sentences consecutive to count 1 and consecutive to each other. Because I think to do anything other than that, given your prior forgery and misappropriation, felony convictions, and your lack of a good track record while on extended supervision would be to unduly depreciate the seriousness of those offenses. But I really looked at this, and my goal here was to kind of hit that target, and that's how I structured it. And that target being to make you eligible closer to a point in time when you are 80 years of age. I think the criteria that I have when I think about not just the seriousness of the offense, but the need to protect the public, that's one of the key factors here as well. You've demonstrated that not only for family members and people that you love, but other strangers, like your prior record shows with the patients from the clinic at which you worked and the mom of the person you lived with, there's really not anyone who's safe from you when it comes to your willingness to steal, to defraud. You'll craft fake documents, you'll try to cover up your tracks, you'll justify it, and then you'll blame others in the process when you get caught. But there's other things I need to go through in terms of the sentencing. In terms of conditions for extended supervisions and conditions of your sentence. Obviously, there's some things I need to go through the statute, but I'll go through them. You have to provide a DNA sample. If you've not previously done so, there's DNA surcharges on all 3 counts, $250 each. There's payment of court costs for each count. I am going to order costs pursuant to 973.06 sub 1 sub B in the amount of $16,728.74 payable to the Waukesha County District Attorney's Office for the expert witness who testified in this case. I'll go through restitution more specifically in a moment, and I realize it will be subject to a request for a hearing if made at the end of this hearing. But I do believe restitution as set forth in the memorandum and affidavit submitted by, I take that back, I don't think it was signed as an affidavit, but there's a memorandum and supporting documentation from attorney Beth Taylor detailing $386,646.01 is appropriate for all of the reasons that are expressed in that memorandum. I'll frankly take judicial notice. She'll be incarcerated for quite a period of time and will not be employed. I don't think that's disputed, but I also believe it's appropriate for this court to set up an escrow account under 949.165. It is the express intent of this court to limit, if not make impossible, the ability of the defendant to profit in any way from the crimes she has been convicted of in this case, and to use monies received as a result of the commission of these crimes, whether past, present, or future, to pay restitution as ordered herein, and to compensate the victims. In other words, this court is relying upon Wisconsin's state statute section 949.165 to order the establishment of an escrow account as a legal means to ensure the victims are compensated from the fruits of these serious crimes. The court finds an order for an escrow account is appropriate under the statute for payment of restitution, as well as court costs, fees, and surcharges, and for costs associated with prior or future legal representation, etc., under the statute. That's not an exhaustive list. The statute's pretty clear on what is may be paid. There is no doubt in the court's mind that homicide and felony theft are serious crimes under sub 1 in 949.165, and that the estate of Lynn Hernan, represented by the personal representative Anthony Poza, are victims under 950.02 sub 4. Not only is restitution to be paid as any condition of her sentence and extended supervision, but it's to be paid before costs or fines, and these financial obligations shall be collected pursuant to state statute and as provided with that escrow account that I'm setting up as well. She's to have absolutely no contact with Anthony Poza or any family members of his. She's to not gamble or have any contact at any casino. She's not to possess another person's personal identifying information, including but not limited to a driver's license, social security number or card, credit card or number, etc. She is to have no employment or service as a caregiver, whether paid or unpaid. She's to complete all other programming as deemed appropriate by the Department of Corrections. Within 48 hours of this hearing, she is to notify her attorney, meaning Attorney Jones, of the location of Lynn Herman's remains. And within 48 hours of that notification, those remains are to be turned over to the state of Wisconsin via their victim witness, who shall then turn them over to Anthony Poza. Just want to look through my notes, make sure I didn't overlook anything I wanted to address here today. I wanted to say this as well to...
Judge, I can provide that location now if the court wants.
Please do so on the record.
Yes, my client's indicated that her mother's in possession of those remains.
Do we know if Jennifer Flowers in the hallway? We'll check. If she is, she's to be brought in. I want to order her to turn them over. If the state would like a written order, please submit one, and I'll order that Jennifer Flower, who's in possession of the remains of Lynn Herman, turn those over to the Waukesha County District Attorney's Office. Would you be willing to serve that upon her, Attorney Nicolai, within 48 hours of being served with the court order? All right, thank you. I wanted to say a couple of acknowledgments to Mr. Poza, his mom, and the rest of Lynn's friends. And I know that at times this has been frustrating. I appreciate the sentiment here earlier today, but I hope I did my best to bring this case to a conclusion, and that through this case, this trial, and today, that you can finally have some closure and begin healing. I know that it's frustrating. It's frustrating for a lot of people, whether it be a defendant or a victim, to go through a court process. It doesn't always go as quickly, and as one thing I will agree with the defendant is that it is going through a court case and a trial is nothing like what you see portrayed in a dramatization. I often tell juries that you cannot try a case and get a verdict in an hour. That's drama. And the rules of evidence oftentimes prevent certain things from coming in that one party or the other might want in. And the flip side of that is sometimes it allows for questioning that may seem intrusive and violative. And I appreciate everyone's patience as we went through this process. You know, I would remind everyone, I mean, the case was filed in 2021. There needed to be a preliminary hearing. That was ultimately, once we got through the arraignment process and the case came before me, we had a trial scheduled in relatively short order for February of 2023. And then there was a request by the defense for an adjournment. And with reluctance, I granted that. And originally we had parts of 6 weeks needed to be scheduled depending on how we started and whatnot. And you can't just find 5 weeks, 6 weeks on anyone's schedule without going out a significant amount of time. And, you know, we don't have attorneys Kukler and Galaviz here, but, you know, from my perspective, everyone worked really diligently to find a time that worked, where we could put this case forward. We had certainly a jury pool who are silent other than the written verdicts that they signed, and I hope in some respects I've given voice and recognition of the guilty verdicts that they pronounced in this case. I found my note that I wanted to reference earlier, and I know I've pronounced sentence, but when I talked about THZ and what it does to a person, and why I believe in the series of events that I've described, and how it was utilized in this case, and why I believe there's, evidence to support it being used for quite some time, is that it impairs memory, it impairs judgment, it impairs inhibitions. It's a substance not routinely screened for, and certainly not in 2018. It's widely available over the counter. It's not a recreational drug. It's used, as I indicated, either maliciously or as intended, or it's ingested accidentally. That as a CNS depressant, it can cause depression, drowsiness, hypothermia, which is low body temp, bradycardia, which is slow heart rate, hypotension, apnea, which is the temporary cessation in breathing, and coma. I didn't say this previously, but I had written a note to myself. I think it was referenced either by the state or by perhaps one of the individuals who made a statement, but I think it was Attorney Sitzberger. Lynn Herndon was left to die on her own. What I wrote is this, that she was dosed and the defendant left her to die alone. Why leave? If not a homicide, you needed a window of opportunity to claim Lynn Herndon committed suicide. I just want to make a further record that while I didn't reference it with specificity in my sentencing remarks, I obviously had referenced kind of generally the PSI, the private PSI, certainly relied upon those in getting background information for Ms. Kurczewski. My reference to the 20 years was obviously to the private PSI as well. The state's PSI did not make any specific recommendation on the homicide other than noting it's life, that's mandatory life under the statute, and then made a recommendation that I deviated from, or at least did not agree with, as to counts 2 and 3. I do want to state with some specificity the restitution that I ordered. I gave the total amount, but it's broken down as follows. For funeral expenses, $3,707.48. For the personal representative's fee, $2,947. For the cash withdrawals and checks from the estate checking account, $54,689.53. For payment from the estate to inheritance funding, $14,000. The payment from Croak, Gonzalez, Eckerly, and Martinson in the amount of $4,700. Additional fraudulent estate expenses as detailed in the memorandum by Attorney Taylor, totaling $42,425.14. Attorney's fees incurred by the state. This includes actual attorney's fees that have been incurred and an estimate of future attorney's fees, which I find to be reasonable under the circumstances, of $18,149. I agree with the reasoning in this memorandum that this is not this is different from normal attorney's fees. These are fees that would not have been incurred but for the fraudulent activity related to the probate case of the defendant, or by the defendant. Mr. Posa, as the personal representative and victim under the statute, he may seek and has sought compensation for time away from work totaling $1,680. And there's additional payments to the defendant from the BMO Harris account totaling $244,347.86 for that total of $386,646 and a penny. I'll find that this total amount of restitution has been established by clear and convincing evidence based upon the trial exhibits and testimony, and as set forth in the attached supporting documentation in document number 616 filed with this court. Now, I indicated earlier, Attorney Jones, that I would certainly, if requested, schedule it further for a restitution hearing. I don't know if you're in a position to tell me that today, but I'd certainly give you some time if you want.
My question to the court would be if the court's considered, and I'm sure you have, I just didn't hear it on the record, the factors under 973.20 sub 13, the ones I set forth in my letter.
Yes, I think I might have only referenced her ability to pay. I took judicial notice of the fact that I've given her a life sentence with the eligibility for parole or extended supervision after 30 years with the consecutive sentences. That's obviously, 40 years after that. Let me just find that letter, and I will add to that if I feel appropriate.
I guess my point, Judge, while you're looking, is if you've considered those factors, which, like I indicated, I'm sure you have, I think that would be the sub and substance of the argument I'd be able to offer at a restitution hearing. So if they've been considered, I don't think that there's more to argue.
I will speak more on part 3. I obviously ordered that escrow account, and what I believe is a very real possibility when you look at the present and future earning ability of the defendant. I'm certainly aware that organizations such as Law and Crime, Core TV, 48 Hours, I believe also AARP, all intend or have expressed interest in the records or writing articles or other things. I believe there's a very real likelihood or possibility for there to be potential income flowing to Ms. Kurczewski as it relates to her story. That's why I ordered the escrow account, and so I considered that. Obviously, she has no dependents, so that I don't need to consider sub 4. I've obviously considered the total loss suffered by any victim. I've gone through that. I'm well aware she really has no financial resources at this time, but I do believe there's the very real potential based upon the public and media interest in this case. I also take into consideration that even with such a significant amount of restitution ordered and the way the statute reads about the payment of costs and restitution from prison monies, there's a cap on that, and it's not something I would deviate from in this case. I think it's appropriate, so I've considered that as well.
Then I'm not requesting an additional hearing.
All right. Anything else from you at this time, and then I'll turn to the state.
No, Your Honor.
I know I have a few warnings to get through and all of that, but before I get through that, is there anything the state has?
We are in the process of filing that order for the production of Lynn Hernan's remains, and then we'll obviously keep the court informed of when that's served on Ms. Flower.
All right. All right, Ms. Kurczewski, you have been convicted of 3 felonies. That means you may not vote in any election until your civil rights have been restored. You may not possess a firearm. That is a felony punishable by a fine of up to $25,000 and imprisonment of up to 10 years. You may also not possess body armor. And for a first offense, that would have a potential fine of $50,000 and imprisonment of up to 15 years, and for any second or subsequent offense, a $100,000 fine and a 25-year period of imprisonment. You also have 20 days from today's date to appeal the decision of the court. Good luck. That does conclude the hearing today. Please follow the direction of the bailiffs in terms of exiting from the courtroom. And I'll look for that order, make sure Attorney Jones sees it first. Thank you, everyone.
Understood.